And good afternoon, good morning, good evening, wherever you are. I'm Janice Kaminer-Resnick, and I welcome you on behalf of the leadership team here at America at a Crossroads. Along with me, our former Congressman Mel Levine and former Los Angeles County Supervisor Xavier Oslovsky. Since I got so many notes from members of our audience asking if we were all okay in Los Angeles, I feel the need to say this. Contrary to what you might be hearing or seeing in the media, LA is not falling apart or being overrun with violent protesters. While there are some areas of the city where protests against targeted ICE raids are taking place, be assured that our city is functioning despite depictions to the contrary, and lawful protests seem to be ensuing despite federal efforts to intimidate protesters. Arrests are being made of those who unfortunately exceed the bounds of lawful protest, but they are a small minority, and I will leave it to that for now. Tonight, we are honored to welcome first-time guest Rachel Barkow, scholar of constitutional law at NYU School of Law and an author. Her second book, Justice Abandoned: How the Supreme Court Ignored the Constitution, forms the foundation of tonight's session and addresses probably the most commonly asked question by our audiences each week. And that question is, what happens when the Supreme Court, the Constitution, and the rule of law are ignored? Sometimes we at America at a Crossroads are especially lucky in our timing and our speaker selection, given what is going on in LA with the deployment of the National Guard and the U.S. Marines without consent, much less the request or invitation of our governor or our mayor. We are so grateful that tonight's guest has the expertise to discuss this latest crisis as part of her hour with us. So welcome and thank you to Rachel Barkow. We also welcome our wonderful moderator, Warren Olney. Thank you for gracing us with your intelligence and your presence. Looking ahead to next week, we will welcome Mary Ziegler, who has been widely recognized as one of America's foremost scholars on all aspects of the issue of reproductive rights. She has written several critically acclaimed books on the subject. Next week, she will be in conversation with Pat Morrison on the topic, The Politics of Control, Abortion Power, and How Abortion Shapes American Politics. And a reminder, if you or your friends prefer listening on the go, all our programs are available as podcasts on your favorite app. Just check the link in our emails or visit our website, which is jewsunitedfordemocracy.org. Our programs are all available after the fact on our YouTube channel. The channel's name is America at a Crossroads. And if you know folks who don't have the patience to listen to a full hour, each program is broken down into several short segments as well. They've been attracting large numbers of younger viewers, so you can look at the YouTube site to see the options for sharing this amazing content with others, and it's all free. Our mission is to reach as many people as possible with fact and evidence-based analysis about the most important issues of the day. It's our way of helping to fight to sustain our democracy. There is a link in all of our emails, so if you know anybody who wants to sign up to receive our emails so they can easily register for our programs, you can send them an email and they can register directly to sign up to be on our list. Finally, we truly appreciate your donations. It is only through your support, both via your attendance and your financial contributions, that we can continue our programming. So thank you so much for donating either online or via the U.S. mail. Now, without further ado, please welcome tonight's moderator, a highly decorated veteran broadcast journalist of great renown, whom we are so pleased to present to you tonight, Warren Olney. Warren, the program is yours.
Janice, thank you so much. You're always very generous, and I appreciate it. And I'm just delighted to be able to talk to Rachel Barkow tonight. As you indicated, she is a professor at NYU School of Law. She is a professor of both criminal and constitutional law. She has served as a member of the United States Sentencing Commission. She has written and testified before Congress on the administration of justice and the separation of powers, two things I think that are going to be topics of tonight. She's also author, as you indicated, of two books, Prisoners of Politics, Breaking the Cycle of Mass Incarceration, and the one you held up, the most recent one, Justice Abandoned: How the Supreme Court Ignored the Constitution. And Professor, great to have you, and welcome aboard.
Oh, thanks so much for having me.
We certainly want to hear about the Supreme Court. We certainly want to hear about mass incarceration, but it seems to me that some of your other areas of expertise have been sort of dramatically demonstrated or have been dramatically coming together here in Los Angeles. And let me start with Governor Newsom, who is claiming that President Trump has violated state authority, the governor's authority, by federalizing 4,000 members of the California National Guard. He says that's his rule or his authority and not the president's. There is video of those officers detaining undocumented suspects for arrest, apparently by immigration and customs officials. A federal court would not issue an immediate temporary restraining order, but did order a hearing for tomorrow. So what is Newsom's case? Where does his authority come from?
Yeah, so I think most people who are listening, we have a sense that there's the Posse Comitatus Act, that we in general don't have the military acting as a police force in the United States, that's just not what the military is supposed to be doing. But there is statutory exceptions to that. So one of those exceptions is there's a statutory provision, which is the one that President Trump used here, which allows the president to call in the National Guard under various circumstances, including repelling rebellion or a threat of rebellion. And what Governor Newsom is claiming is that under that statutory provision, the last part of it says that the president is supposed to do it through an order of the governor. And Governor Newsom says the order never came from me, that wasn't done through me. Therefore, it's a violation of that statutory provision. If I had to take a guess, I would say that that argument is probably not going to succeed in court. And the reason that that's my guess is because although President Trump used that statute in this instance, there's another one that he could have used, which is the Insurrection Act. And listeners might have heard about that too, because President Trump brought it up a lot on the campaign trail. He was very excited to use the Insurrection Act. He said he was going to use it if he was elected again. And what that law allows the president to do is, again, similar language about stopping rebellions, to call in the military to repel. If the president thinks there's an emergency, then the president can call in the military to quell that emergency. And under the Insurrection Act, it doesn't mention having to go through a governor. And the Supreme Court has decided cases that basically say it's the president's call whether there is an emergency or not, that the court isn't going to second guess that. So the Insurrection Act clearly gives the president the authority to do what he's doing right now, legal authority. The fact he used this other law, the one that allows him to call in the National Guard, I just think it's unlikely a court is going to say, well, because you used this one and you didn't talk to Governor Newsom, it's not okay. I think they'll probably just say that language at the end of that statute is more of a kind of ministerial function, that just, the order gets processed through the governor, but it's not that the governor has to give permission, because it does seem like when Congress created these laws, they were designed to give presidents the authority to deal with unexpected emergencies. And, we've been very lucky in America's history because we've had presidents who have respected the fact that you don't want the military on the streets of America. So these, they haven't been used. These statutes have been used really rarely in America's history. But that's because we've had prudent presidents. We're in a different time right now, and President Trump has long indicated that he wants robust use of these exceptions. So I wasn't surprised that he did this personally. I actually wrote about this when he was campaigning, because he talked about wanting to use this authority. And I think it'll get upheld in the courts, even if for some reason the governor succeeds in saying under this provision of the law that was actually invoked makes it not okay, the president could do the exact same thing under the Insurrection Act.
Let's go back to this question, though, that the governor is raising, and the issue of the military being used for police activities in the United States. That goes back to George Washington when he founded the Army of the United States, which is going to be celebrated for its 250th birthday later this week. He said that the military should not be involved in politics, should not be involved in enforcing the law, civil law. And you mentioned the Posse Comitatus Act. I don't know that everybody is familiar with that. Tell us about it and why it gives him the governor authority.
Yeah, so that law states that we don't have the military engaged in policing in America. So, that's the general rule. I think the way to think about it is that our country was founded on the principle that, we don't want a standing army. We have a Third Amendment that says, you can't be required to quarter soldiers. We don't want a standing army. We don't want what we fought a rebellion against in Britain, which is to have military type rule and that kind of police state. And the Posse Comitatus Act essentially puts that into law to say that the military will not serve domestic policing functions unless, authorized by Congress. And so that unless part is where these two laws that I mentioned before come in, because Congress did at the same time, almost from the beginning, pass the insurrection. We have this Insurrection Act that allows the president to call in the military if it's necessary because there's an emergency. And then there's this other law that was invoked here in Los Angeles that allows the president to call in the National Guard. And I should say, by the way, when President Trump called into effect this current law, he didn't just limit it to Los Angeles. His executive order actually authorizes National Guard troops to be deployed anywhere in the United States. So even though right now we're seeing them in Los Angeles, they actually could be deployed anywhere where the president decides there's similarly a need to protect some kind of federal interest.
Governor Newsom made that point when he made a speech last night, a speech addressed not just to Californians, but others as well, saying that this does, in fact, affect everybody in the United States. And there have been suggestions that there might be military called up in other places. I don't know. I wouldn't attempt at this point to try to list them. And I don't know how far people have gone in suggesting that this might happen, but the governor is very strong about it. He says the democracy is at risk, and so it's an important issue. I'm fascinated that you think that the courts probably will not go the governor's way, but allow the president to do this, and that will create a situation in the United States very different from anything we have seen before. We have not had the military doing that. And as I understand it, there is now a video that's been released by the Defense Department showing the Guard personnel detaining suspected undocumented people for arrest. So they're not actually arresting them, they're only detaining them. This gets down to how many angels can dance on the head of a pin, I think, but these kinds of arguments are going to come up.
Yeah, no, it's a very dangerous, so we've been talking about whether the legal authority exists and whether or not it might get upheld in the courts, but just as a policy call or as a prudential matter, I think it's insanity because you're basically taking a situation that was already volatile and you're really putting more more powder and then more, you're inflaming it more by bringing the military in. They're not trained to do domestic law enforcement. This is not what they're trained to do. We have police forces in America that are, and there was no evidence that the police were incapable of dealing with the situation. But President Trump has been itching to do this. I think if people look, you'll see you can go back to things he said on the campaign trail. And one of the things I recall is, he wanted to invoke the Insurrection Act and use the military in what he called crime dens, which he said were cities like New York and Chicago, where he claimed the police weren't doing enough to just deal with local crime, which is, I live in New York. We do not need the military to come in, and things are fine. But he was already laying the groundwork for that on the campaign trail, saying, I could call it, I'm gonna do it to deal with crime dens. So I think what we're seeing is he's been itching to do it. I think he saw an opportunity in Los Angeles when it looked like the protests in some sporadic instances got violent. And I think he's trying to desensitize people to the notion of having the military on the streets. I think we should all be shocked and appalled to see the military engaged in everyday policing in America. But I have a feeling that part of his strategy is to get people kind of used to it. That is kind of what he does. He pushes norms, and before long, people just accept them as a new normal because, he does something outrageous. There's a reaction initially that says, this is outrageous. This has never been done before. And then people start to get used to it. And then, he pushes the window even further. And I think that's what he's doing here. I think he's starting with this. And my guess is he would like to use military force more broadly. And, you mentioned that parade. It's the same kind of thing. We typically don't have military parades like, you would see in North Korea or, countries that celebrate a strong militaristic state. When we've had them, it's been to celebrate, victories in wars. But the idea that you would have a parade like this in peacetime is, again, it's an authoritarian move. It's the kind of thing that authoritarian leaders do. And it's all part of a package of things that Trump said he was going to do when he ran for office. And it very much fits that blueprint.
And it's worth pointing out, I think, that it's not just the federalized National Guard troops. There is also a contingent of Marines
Yep.
Trained in combat and not in civil disturbances, who are evidently being retrained in some way. I don't think it's very clear exactly what they're supposed to be doing, but the fact that active duty people might be involved is very interesting. Why do you think the president didn't use the second act, the Insurrection Act, and do you think the courts are going to do it for him?
It's interesting that he didn't. And there are some legal commentators that applauded the fact that he didn't, because, that is a more extreme measure. The Insurrection Act, I think, would be validly viewed as a broader measure than calling in the National Guard. And so in some ways, you could view this as a more limited form of him using military force. I don't normally think of him as an incrementalist, so I don't know why he didn't just go for the Insurrection Act right off the bat. I mean, it's possible that the idea was, again, just kind of pushing that envelope, getting people used to this, and then going forward with the Insurrection Act later. But I'm not sure. They didn't say why, and we have no indication as to why he invoked this authority as opposed to the other. But I do have a feeling when courts are interpreting this provision, they're going to be aware that there's also this Insurrection Act authority, and I think it'll color how they view this one as well.
Before I get to the Supreme Court and the issues of mass incarceration, our theme, what happens when the Constitution, the Supreme Court, and the rule of law are ignored? Obviously, that sort of happens on a case-by-case basis, but is there, do you think, some sort of overall rule that applies or practice that applies when that happens?
Yeah, so I think it's important to know that so there's two things we can think about. We can think about the president defying a Supreme Court order, which he hasn't, so far that hasn't happened yet. We have had disputes over whether or not he's made good faith efforts to comply with instructions from the Supreme Court, but there's no evidence that he's actually defied a court order. So I'd say that's one category of things to be worried about. What if we get to the point that the Supreme Court says you must do X and he says, no, I won't? What happens then? That would be, that I would say is the most catastrophic circumstance that we could find ourselves in. That would be, in my estimation, the gravest threat to our democratic order is if he defies the Supreme Court openly, because then we're in full bore constitutional crisis. The kind of second way to view your question is less about, a president defying something that the Supreme Court says, and the Supreme Court itself kind of recognizing that it doesn't want to go so far as to push that confrontation to happen. Kind of the court is sensitive to knowing when it issues orders, how they might be received. And if the court thinks that a particular order might get that kind of pushback, it's certainly possible that some of the justices might try to kind of mediate what they would otherwise do to avoid getting us to that constitutional crisis moment. So, if they thought that if they issued a decision that required the president to do something, that the president would say, absolutely not, I won't do it. They might think, okay, how could we write this in a way that avoids that crisis moment? Could we say it in a simpler way? So, for example, the case that involved Mr. Abrego Garcia, who was the man who was erroneously sent to El Salvador in violation of a prior decision that said he shouldn't be sent there. The Supreme Court in its decision said that the president should facilitate his return to the United States, and I think using language like that is the kind of thing that the court could do to avoid the confrontation, right? Because then you start to have a debate. Is he actually defying the court order? Is he facilitating or not? Versus if the court said, you must bring him back. If the court had said, you must bring him back, and then the president didn't bring him back, that's where we'd be at the full crisis moment. So I think what we're witnessing now is a situation where there's a little bit of a dance between the court and this administration trying to figure out how far will they go to say things that might prompt that resistance from Trump. And I think, for most of American history, the court hasn't had to think too much about that, other than the Civil War and the one time that we had to deal with that before with President Lincoln. This is just not a situation that has come up in American history because we have had presidents who have fully understood that our rule of law in America depends upon adhering to Supreme Court decisions, that's part of our constitutional framework and separation of powers. And the new territory that we're in now is we have a leader who has authoritarian tendencies. He's expressed them very openly. He's not he's not really one to think the other branches serve much of a role. He sort of sees himself as the supreme leader, and he doesn't really like checks on that. And I think that's what puts us in these situations now where we're asking questions of what do we do when we have a president who doesn't seem to share the commitment to these other institutions that we have historically had presidents share. And so I don't think we're at that crisis position yet. As I said, I think the court has been careful in how it's issued its decisions so that we've avoided it. And that's another reason why I think courts dealing with what's happening in Los Angeles now and the use of military force, again, I think they are likely to read these laws in ways that give the president broad authority, that there's precedent for doing it. And again, there's these pragmatic considerations that basically say, let's not push a confrontation if we don't have to.
But if that happens and the court tiptoes around it in the way that you suggest, is it then quite likely that we will see military people involved in activities and enforcing the laws or whatever on the streets of our country, which we've never seen before?
I mean, it very well could happen. And again, I think that people voted for this. It's hard to always know, how much attention people pay to what candidates say when they're on the campaign trail. But when I wrote about this, I said, look here, I just used the words that President Trump had said in speeches on the campaign. So it wasn't even like you had to guess like, oh, Project 2025 is saying something, and is the president going to endorse it or not? This was coming from his own mouth where he said, I want to use the Insurrection Act to deal with crime dens in America. I'm going to call the military in to deal with places like New York and Chicago where the police won't. And so to the extent that voters heard that and they voted for him anyway, I think it does reflect that we probably could use a lot more civics education in America, about what some of the values are that we should all hold dear. But then I think there's a not insignificant percentage of the American population that is comfortable with it. They're comfortable with this idea. And, what makes this all very tricky is if the court isn't going to be the institution that stops it, and again, I don't think they will, because I really do think the way the Insurrection Act has been interpreted, it's going to be very hard for that to be a successful challenge, then the pushback has to be political. The pushback has to be that the people themselves in America say, this is not the country we want. And, usually the way that you do that is you do protest, you do openly go out there. And part of what I think that Trump is trying to do is scare people, to scare them to not protest, to frighten people to go out into the streets and express their viewpoint. Because I think, the administration has to know that's the most powerful form of pushback, is for the people to let it be known what they want. Obviously there's the ballot box and electing different people in the midterms and for other positions. I should say, by the way, another thing that he did mention on the campaign trail is he wanted to invoke the Insurrection Act to seize electoral machines. He talked about potentially doing that as well. So we haven't even necessarily seen the worst of what could come.
Yeah.
But that's the way we have to guard against this. It's about voting. It's about pressuring our elected officials. Congress could obviously step in. There were a lot of people that asked Congress between the first Trump administration and now to amend the Insurrection Act, to put in some restrictions so that it couldn't be so easily used by presidents. And it was not amended, it wasn't reformed, and so we're in the same position that we were in before. And the big difference between the first Trump administration and the current Trump administration is the other thing he's done that's different is in the first administration, we had people in the Trump administration who were rule of law types. There were lawyers, there were other people who said, you can't do that. People who worked in the Defense Department, who understood the limited role of the military, who did not want the military involved in things like this. And the other big shift that we're seeing is that he has appointed Trump loyalists to all these key positions. So these are people who have been pre-screened precisely so that they were people who said, my loyalty is with Trump. If the president gives me an order, I will follow it because it's his decision to make. And, it starts with Pete Hegseth, and then he has gotten rid of tons of people in the Defense Department because he also wants loyalists working for him. And so the other danger I think that we're viewing now in Trump 2 as opposed to Trump 1 is you just have fewer people inside the administration who are likely to raise their hands and say, no, you can't do this. Instead, I think what you have are people who will go along with pretty much anything.
I think it's really important, just one last word on this, in the context of what we're speaking, to really emphasize what Janice said at the very beginning of this program, that Los Angeles is not burning down, despite the fact that there were some Waymo cabs that were burned by people who apparently didn't have anything to do with the demonstration against the ICE actions, but are simply professional agitators. There was that. But also the area of the curfew is 1 square acre, not square, but 1 acre in a city of 500 acres. And the local authorities are very well able to take care of disturbances in that area, and they're doing a good job of it. So much for all of that. Let's get to the book, and very specifically to mass incarceration. And you begin with an extraordinary statistic about where the United States stands worldwide in the area of mass incarceration.
Yeah, and I think it's not unrelated to what I was just talking about, where we have a large segment of our population who seems comfortable with the idea of potentially having military force on our streets. We also have large percentages of people in the American public who are very comfortable with using prisons and policing in a very broad manner. So the United States has about 5% of the world's population, but we have between 20 and 25% of its incarcerated people. So we're really we're definitely playing above our weight in terms of the number of people that we incarcerate. And that is something that's relatively new in American history. It's really only since the 1970s that America has diverged from other countries. Before that, we looked like other Western democracies. We had about the same incarceration rate as other countries in Europe, other countries that look like us in terms of democratic commitments. And really things started to shift towards the end of the 1960s, early 1970s, when we started ramping up incarceration in America. And the dynamics were not entirely dissimilar to some of what we're seeing with the Trump rhetoric, which is basically, you had Richard Nixon in 1968 ran on a campaign that was very much a law and order. We got to take back the streets. There's a need for us to get tough on criminal law in America and punishment. And that really kicks it off. And again, he did some things where he pushed the constitutional envelope after he was elected. And the Supreme Court said, oh, okay, we're going to let you do that. So it wasn't because it didn't come out of nowhere. Homicide rates were higher at the end of the 1960s in America. And, similarly, we were looking at a time period where there were a lot of protests, and a lot of those protests turned violent, a lot of property destruction. Some of them turned to riots. Cities were burning across America in the late 1960s. And so in climates like that, people get very afraid. And when people, voters are afraid, they are very much susceptible to candidates who come in and say, I'm going to bring you a peaceful resolution. I'm going to give you back the kind of security that you had before all this happened. And that was the dynamic that really set off America turning to this very punitive approach to crime.
Well, what are the consequences of mass incarceration? Does it in fact reduce crime?
That's the tragic irony is, we, I think people have an intuition that let's, lock people away and that'll solve all problem. But 95% of the people who are incarcerated come back out, because you don't incarcerate people for the rest of their lives, no matter what they've done. And when they come back out, a long period of incarceration is often counterproductive. It makes it that much harder for people to settle back into a law-abiding life. So no, it's not. It's costs a ton of money. There's way more cost-effective ways to deal with criminal behavior. So, in fact, most of the things we do when it comes to crime and punishment in America are not only cruel, but unnecessarily expensive, and really, it's communities of color that bear the brunt of it too. The kind of racial disparities and how all of that stuff gets administered are really stark.
You talk at length in your book about 6 different cases involving the U.S. Supreme Court in such a way that you suggest that it is, in fact, well, I'll let you make the case. What about those 6 cases overall? What has the Supreme Court done with respect to mass incarceration?
Yeah, so I'll give you one example that I think is just helpful in light of what we're talking about in America today, because the parallels are pretty. You'll see the parallels. So as I mentioned, Richard Nixon ran in 1968 on this law and order campaign, and he actually was also running against the Supreme Court. A lot of people who study the court know in the 1960s, there were a couple big decisions that it had that, people kind of think the heyday of the Warren Court is that they decided a case map versus Ohio, where the court said, look, if the police obtain evidence by engaging in unconstitutional searches, you got to exclude that evidence from somebody's trial. Like that's known as the exclusionary rule. And the other case the court decided in the 1960s was Miranda, which, people I think are aware of from watching TV and movies, where people are read their rights, that they have a right to counsel. And both of those cases, Mapp and Miranda, were politically not very popular in America. There were editorials written in newspapers. The police hated them. And they used the court, they basically blamed the court for deciding those cases for why there was so much unrest in the end of the 1960s. They said, part of the problem is the Supreme Court. And so in 1968, part of the campaign, people had signs on their lawn that said "Impeach Earl Warren." So the idea of the Supreme Court kind of being part of the dialogue in America and kind of what it's that's not new. So to the extent people I think now it's a big deal with the Roberts Court, it certainly was true back at the end of the 1960s. So when Richard Nixon, and he campaigned explicitly against the court, he criticized the court on the campaign trail. He promised he would appoint different kinds of justices and he would be a law and order candidate. And George Wallace, who was also running, did the same thing. So when he's elected, he realizes he has to do something about crime, Nixon. And he kind of, I think, realizes, as most presidents do, president of the United States actually doesn't really have a lot of authority over crime in America. Like their policing is local. Those kinds of policies are local. And so what he decided to do is he thought he would create this new law in the District of Columbia where you could detain somebody after they had been arrested for a crime if you could demonstrate that they were dangerous. Now, for 200 years in America, you could not do that. You're presumed innocent, right? You get a trial. And if for us to detain you because, we think you engaged in criminal behavior, we have to prove that you engaged in that criminal behavior. Now, if we want to just detain you because we say you're a danger, there's civil commitment proceedings for that. So this was going to be the first time that there was going to be a law that said, no, all we have to do is just going to arrest you for the charges. And we're going to use your arrest as the basis for locking you up. So this kind of new idea that Nixon comes up with, he asks one of his administration lawyers, William Rehnquist, who's later going to become the Chief Justice of the United States. But at that point, he's a lawyer in the Nixon administration. He helps draft this law. He drafts this law for the District of Columbia. And ultimately, it would allow you to detain someone for up to 60 days after they'd been arrested if the government could prove they were substantially likely to win their case on the merits. It was pretty limited because they knew they were testing the constitutional waters, because no one thought this was okay. But they made it very limited and narrow. And ultimately, that law, it doesn't apply in very many cases because it is hard for the government to win, but it gets upheld in the lower courts. And as soon as it does, and this was Nixon's plan, it gets adopted. Other states say, hey, we should have laws like that. We should also start detaining people pre-trial by claiming that they're dangerous. And so the law that idea spreads, and including at the federal level, Congress passes a law. By the time Congress passes its version, it's like over a decade later, and people had become so desensitized to detaining people pre-trial that by the time Congress passes its version of this, there's no cap on how long you can be detained. There's no requirement that you show you're likely to win on the merits of the case. And in fact, Congress creates various presumptions that say, well, you're charged with a drug crime that has a statutory maximum of 10 years or more. You're presumed dangerous. You're just presumed dangerous because you sold drugs. And so you could be detained. That law that Congress passes becomes the law that gets brought to the Supreme Court in 1987. And it's the first time the Supreme Court had ever considered, could you detain somebody on the basis of an arrest because you claim they were dangerous? And if you were an originalist, and I go through this in the book, I explain absolutely not, you could not uphold this. There's no way, the framers would never have allowed this. The Supreme Court, in an opinion by, and you probably are going to guess who it was by. By now, Bill Rehnquist is on the Supreme Court. He writes the opinion. And he says, yeah, it's all fine. He's like, the presumption of innocence, that's just a burden of proof thing. But this is just like a regulatory matter. The state can, if it feels like it needs to, regulate things to keep people safe. And the argument he uses for that is based on the brief filed by the government in the case, the Solicitor General's brief. The case it cites to support this idea that sometimes, you have to do things like this to prevent dangers is this case called Korematsu. And some people might be aware of it. That's a Supreme Court case that upheld the internment of people of Japanese descent during World War II. It's really a blight on our Supreme Court case law. The modern court has actually disavowed it and said, Korematsu was terrible. It was a terrible moment for us as a court.
It's still in effect, isn't it?
Well, the court has kind of disowned it, but it's unclear, if it hasn't officially overruled it. And so, it's kind of unclear when the court sort of said that, what it actually meant. But at the time that this case was decided in 1987, the court hadn't made that pronouncement yet. And so the Solicitor General cites it as if it's just any other case and it's fine. And that is the basis on which the court upholds pretrial detention. And, the reason I think that case is a good example for us to think about now is it was a very similar dynamic where you had a government that decided they wanted to test constitutional boundaries. They wanted to do something that had never been done before, that no one thought was legal. And, the way they did it is they started it off with this more limited law. People get used to that. Then they expanded. And then, now if you look at today, when I talk to people about pretrial detention, people think I'm nuts when I say you can't detain people just because they've been arrested. People say, well, of course you can. They're dangerous, and they've flipped what I think people think the norms are. And so I do think that all goes back to a Supreme Court that was just unwilling to enforce the constitutional boundaries that existed. The court should never have upheld that. But I think by the time it gets to the Supreme Court, the court felt pressure, to go along with what the government was saying, as the court often does. The court often, when is faced with a government argument, I think feels pressure to defer, to say, hey, the government knows best about what keeps people safe. And the other cases in the book have kind of similar backstories about deferring to the government, not wanting to second guess, even though the Constitution itself says otherwise.
We have reached the time when it is appropriate to go to the chat section and get some of our listeners and watchers to ask questions. We want to give them an opportunity to do it. Let me just say that I could listen to you for a long period of time without asking any questions, and I would be better for it. But they always have good questions, and I think that it's important for them to participate. Here's Terry, for example. She says the real issue is not that what is happening in Los Angeles is not an emergency. Can a president by fiat declare an emergency with no accountability? What determines the facts of the emergency? Who has any jurisdiction over that?
Yeah, so it's a great point. And, I think you or I might have an intuitive sense that there should be some review of that to make sure it really is. But there is a Supreme Court case on this one. So there was a case, Martin versus Mott, that it's a very, it's over 100 years old. And the Supreme Court in that case said that what counts as an emergency is effectively the president's judgment. We leave it to the president's judgment to decide. And again, I think the court gets to decisions like that from a place where the court doesn't want, first of all, the court doesn't want to put itself in the position of deciding what's an emergency. I think the justices are sensitive to the fact that they're not elected. And so I think that's part of it. And I think part of it is this desire not to find themselves in a confrontation where the court says, it's not an emergency. President thinks it's an emergency. And if the president truly thinks it's an emergency and calls in force, then the president would be defying a court order. So again, I think the case law is pretty clear on this, that it's up to the president to decide whether we're in an emergency or not. And I do not think this current Supreme Court would overrule that case. I think they will adhere to it.
Another question that goes to a similar issue from Ruth. There are going to be a lot of demonstrations against the military, or not against the military, but against the Trump administration in general during the alleged celebration next week or this week. Ruth wants to know this. Trump has threatened that anybody protesting his birthday celebration on Saturday, she calls it a birthday celebration for him rather than for the army, will face serious consequences if the protests are peaceful, but Trump sends out the military to go after protesters, Putin style. What recourse do detained, arrested, peaceful protesters have if he sticks the military on them?
Yeah, they can certainly bring First Amendment challenges to say their arrest was unlawful, to get their charges dismissed. The problem is, that's kind of cold comfort if you've been detained in the meantime. And so I think what he's trying to do is intimidate people to not come out in the first place. That's clearly what he's doing. That's clearly what is happening in Los Angeles is, the message being sent is stay at home, let us do whatever we want, don't exercise your First Amendment rights. But if people do, and they're peaceful, that you can't arrest people who are peacefully protesting, right? That is a First Amendment violation. And so people would be able to successfully challenge that. But again, it's kind of after the fact, if that would have to go through a court proceeding. And in the meantime, they could find themselves arrested and detained and facing, the really unpleasant and scary notion of butting up against military force or police force.
Another question that doesn't come straight out of the conversation we've had, but it's a very interesting one from Robin. A news article says that provision of the big, beautiful bill would make it very difficult for a court to hold the administration in contempt. What would be different than how the application of contempt of court works? I'm sorry, you understand the question?
Yeah.
How would that be different?
Yeah. So, it's not as different as you think, actually. So I think the questioner is getting at something very important, which is even now under the current law, if the, whatever they call, I can't call it the big, beautiful bill. It's like such a ridiculous moniker, but that legislation, if it did pass the contempt.
The official name of it.
Yes, I know. And it's really difficult to say. So that legislation, if it did limit the ability to hold people in contempt, I don't actually think practically it's as big of a deal as people think. And the reason for that is right now, if a judge were to hold the administration and administration official in contempt, it'd be up to the administration to enforce the contempt order of the judge. And there are some provisions that would allow the judge to appoint someone else to do it. It's unclear whether those would get upheld by the current Supreme Court. Again, we have another whole issue where some of the justices have indicated they don't think that's appropriate. But even if that were possible, that you could have someone else enforce the contempt, the president has the ability to pardon anybody who has been held in contempt in federal court, because that is a federal offense. And so the president could use the pardon authority to release someone from liability. So even now, today, there's a way for the president to get entirely around that makes it so if this change happened, it would certainly require the president to go through fewer hoops to get to the same result. But the president can get to that result today by use of the pardon power anyhow.
Just one quick point. I have been called upon to correct something that I said. The curfew area in Los Angeles is not 1 square acre; it is 1 square mile, and the size of the city is 500 square miles, not 500 square acres, which I said earlier. I apologize for being being wrong. A lot of people have asked this in different ways. Is there no check on the president's judgment? Is there no factual hearing that can be held with the court determining facts and getting the president to do something?
Well, it depends on the context. Some things, yes, there are some things where there would be an underlying hearing. For example, if someone were arrested and they asserted their First Amendment rights, we would have a hearing to decide, were they in fact violent? Is there a grounds for their arrest? But the questions that people are asking about this question of, is there an emergency? Is there a rebellion? Is there an insurrection? Those kinds of questions are questions that our courts have said are not questions that are judicially reviewable. Those are the kinds of questions that, they're known in law. They're political questions. They leave it up to the political actor of the president to make that decision. And so to the extent there's a check on that, the check would be us as voters saying, we elected somebody who sees emergencies where they don't exist, and we shouldn't have elected somebody like that. And therefore, next time, we should elect people that are going to be more prudent in the exercise of that power. So in that context, there is not judicial review, at least as I said, under the current Supreme Court case law. So unless the court is going to change what it said about what counts as an emergency and who gets to decide, as of right now, it's the president who decides that, and there is no judicial review.
A couple of people have asked this about the military, which it is said is not obligated necessarily to follow an illegal order, if that's the way they perceive it. What's the status of that rule? And could military people refuse to take the kinds of actions that Trump might be ordering?
Yeah, they take an oath to the Constitution, not to the President of the United States. And so they should be complying with the Constitution. If they're given an unconstitutional order, they shouldn't follow it. But, if I think, I have a lot of sympathy for the people who are in that situation you can imagine how difficult it would be for a soldier to try to personally assess, my commander in chief has ordered me to do something. Who am I to question that decision? And as I mentioned before, we have had by this administration, they have gone out of their way to fill the administration with people who are of the view that you just follow the president's orders, that in fact, what's constitutional is what the president says. President Trump has said this on many occasions, kind of the I am the law, what I say is the law. That is what you're supposed to do. And when they hired people for a lot of these positions, this was part of that whole Project 2025 thing and the Heritage Foundation. There was some discussion of this during the campaign. They were screening people for positions in the administration. And some of their screening questions for hiring people were basically questions that asked, if the president gives you an order, do you follow that? And by the way, people were asked this not for positions, for example, in the Department of Justice, where, again, we normally think of the Department of Justice as you take an oath to the Constitution, you cannot let the president do illegal things. But people were deliberately selected and hired for those spots because they had the view that really what we are supposed to do as workers is just do what the president says. And the military has had a similar campaign. For people who have followed this, Hegseth fired a ton of people. He removed them from their positions and he replaced them with loyalists. And so you're getting more and more people through the military chain of command who have this view that we just do what the president says. It's, we're gonna do what the president tells us to do, and we're not going to second guess. And so you're losing what had been a traditional check in our military against presidential overreach, was that you definitely had people who understood there are some orders they shouldn't follow. But I just think think that has been neutered somewhat by the way that people have been replaced in those positions. And then, to ask it of people in the lower ranks, is asking a lot of people, because you run the risk of being court-martialed. If you're wrong and you disobey an order and it's found to be lawful, then you could find yourself being disciplined as a result. And so I think, realistically speaking, it's hard to expect too much pushback. I think a scenario where you would see it, where you've seen it in other countries that are authoritarian countries, where leaders have asked their military to do things and they've resisted, it tends to be situations where there are clearly just nothing but peaceful protesters, grandmothers, the elderly, children. They're in a protest and they've been ordered to shoot. And you see in countries that have authoritarian rule, that's often situations where the military just, that's where they say no. They recognize the immorality of it, and that's sometimes when these regimes collapse, is when they push the envelope so far that you have rank and file service people realizing we can't do this anymore. But it has to get pretty far for them to do that. So if the order is simply, we're going to issue immigration, you're here to protect ICE officials as they go about their immigration enforcement to make sure that they can do their job safely, I don't think you would have service people who would second guess that. I think they're going to police crowds in those situations. We have to all hope that it doesn't turn violent, that people don't get killed, that it's all done in a way that it doesn't get out of hand. It's certainly a worrisome situation because the military is not trained to deal with civilians in those civilian contexts. But I think that they will follow the orders that they're given unless they are so blatantly over the top, shoot innocent civilian type things that that's unlikely to be the place that we would see pushback, I think.
Linda has an interesting question. Assuming, as a lot of people do, that we elect a majority of people in Congress next year who want to legislate against the misuse of power, what would you recommend that they do in terms of restraints to presidential power? I presume it might depend a lot on how big the majority is.
Yeah. No, that's a really good point about the size, because, of course, to get any legislation passed in America, if the president decides to veto it, then you need to override the veto. And it's highly unlikely that we would have such a shift in our in either house that would allow the override of a veto, that I think realistically it's probably not going to be through legislation, I think. But I do think it could be in things like confirmations, who they accept to get confirmed for positions as positions open up. You could start having hearings where we uncover some of the things that are happening. Potentially, there could be some things that are so unpopular that they are veto proof, and you could get overrides of some things. But I think, certainly anything is better than what we're seeing now, which is effectively nothing. Congress has done almost nothing in the entire time that this administration has been operating. At least the only time that I've seen really any appreciable pushback was when there was a threat to the bond market after the tariffs were issued. When it looked like it was posing a threat to the stability of the bond market, there were some Republican senators who spoke out at that point. But that's all I recall. I mean, other people may recall stronger pushback that I just missed or didn't see. And so I think if there is a shift in, the majority, if the Democrats take control, that you would see certainly more pushback than what we have seen, more highlighting of what is wrong, hearings, attention to the matter, and potentially enough that some Republicans go along with it, and you actually do get actual legislation that fixes it. But it'll be hard. It'll be hard because of the veto. But I think, another thing that happens is people say courage is contagious. So I think, if you do start to have people who stand up, maybe it'll break the spell for some others, and they'll realize that this certainly does not look anything like the Republican Party has looked for most of my lifetime. And I think it's possible that if things start to shift, they could shift big, and there could be a stronger repudiation of him, because the other thing they're going to be looking at is, in 2 years, someone has to run. assuming he doesn't take over the ballot boxes, we don't have a full-on coup, and we have an election for president, the Republicans are going to have to think long and hard about what they've set themselves up to look like in that election. And again, that could potentially bring about stronger pushback if these are really unpopular positions that he's taking.
Terminology can be so important in all of these issues. Brad wants to know, how is insurrection defined in law, if it's defined at all, or is that a case of the president having a judgment different from somebody else?
Yeah, I think it's going to be the latter. I think that it's not defined, and it's the president's, that courts will just defer to what a president says if there's a necessity, because the president, again, it's that language of insurrection or emergency. Again, I think people are probably thinking to themselves, I have been anyways, that the president certainly didn't call in the National Guard on January 6th, when it looked far more like what I think maybe a everyday common person would say that looked like an insurrection, when people were storming the Capitol. But ultimately, I think the courts are going to say it's the president's call.
Douglas says, isn't it actually the law that you must refuse an unlawful order if you're in the military? I think you made some good points about the difficulty of getting a military person to do that. And I wonder how strongly that's taught. I was a draftee at one point. I don't remember in basic training getting any instructions about that.
Yeah, no, and I was not in the military either to be able to comment on. So I'm sorry. Hopefully, you get another speaker that can address him. I think that that's right. That you're under, you take a duty to the Constitution,
Yeah,
and so that is your paramount duty. But I don't know how the training is. I don't know the specifics. Sorry.
And Stuart is another one who wants to make the point, which you made yourself. How do individual Marines or National Guardsmen make a determination like that? It seems to me it puts an enormous responsibility on somebody who's probably not really well enough informed or competent enough to make it. It's an interesting point, but it becomes pretty academic at some point. I we have a tradition in this program that at the end of the program, we like to give the guest an opportunity to say anything that he or she wants to, that would be positive, that would leave people with a with a good feeling. That's a sort of a memorial to a man who worked on this program at the very beginning and who unfortunately has passed away from us. But what about it? How do you look forward, or what are you optimistic about the future? Is there any way to feel that way?
Yeah, I mean, I do believe the courage is contagious quote. I feel very strongly about that. I will say, my husband works at the law firm Jenner and Block, and some of you may know some of the law firms that faced executive orders by the president capitulated, and they reached deals. And they didn't fight, even though those orders were blatantly unconstitutional. And other firms like Jenner fought back. And one of the things that I think has been really heartening seeing that is that the firm, not just Jenner, but Perkins Coie and Wilmer Hale, that the firms that Sussman Godfrey that are fighting back, I think they are getting support. They won their court decisions. They show that you could stand up to this and you can win when you fight for the principles. And so, I think Harvard, is fighting against again on really a campaign of unlawful intimidation. And so I think as you see more institutions in America fighting back, I think it gives people hope that we can all do that, and that I think more people are opposed to this kind of militaristic authoritarian notion that are in favor of it. As I said, I mean, I think it's a sizable number of people who like it, and that is frightening to me that we have anybody that thinks that's a good thing for America. But I don't think it's the majority. I think the majority, a sizable majority, do not want that. That we do love our freedom in America. We do love the fact that there's limits on the government, and I think we just need everybody ready to stand up and fight for that in whatever sphere they're in. So if it means that you can peacefully protest, you peacefully protest. If it means you have an unlawful executive order come at you, you fight it. You do what you can in your sphere, and if we all do that, I think then collectively there's pushback, and it will stop the administration from being able to do that, because I think that what they're banking on is getting enough people to just cower in fear and accept a new normal. And I think that what we have to do collectively is just not allow that to happen, is to fight for the values that I think are really at the core of our country, to never accept the idea that having the military on the streets of America enforcing the law is something that's just not a country that we want to live in. And to make that clear to our elected leaders. And even if that doesn't mean you win successfully in a court challenge, you can in other ways express dissatisfaction with that, such that people will lose their elected office if they support it. Any politician that doesn't speak out against that, I think voters should make clear you're going to vote them out, that you want them speaking out against that. So I guess I would say that, I think it's just really important for people. I don't think the courts will save us. Part of my book is, unfortunately, that message is they tend not to. Sometimes we get some good decisions. I always hold out hope that we'll get better ones, but ultimately in America, I think it's up to the people to fight for these rights and make sure that they get protected. And so that, I guess that's the optimistic note that I would leave on, is that I hope we all do that.
And it appears that there is a lot of organizing going on, or at least it's beginning to that's beginning to be the case, and we'll see what happens this coming weekend. Rachel, it's just been wonderful to talk with you, Rachel Barrow, Professor Barrow, I should say, Barkow, excuse me, Barkow. And it's really been fascinating. I've enjoyed it very much, and I know that all of our listeners and watchers have as well. So thank you so much.
Thank you. It's been a pleasure talking with you. Thank you.
Okay. Next Wednesday, I want to remind everybody, July 18th, one of the country's foremost experts on reproductive law, UC Davis professor of law, Mary Ziegler, is going to be in conversation with Pat Morrison. The politics of control, abortion, power, and how abortion shapes American politics. Another fascinating story. I look forward to that. And thanks everybody for listening and watching.